in New York State. And Glendora went to press for justice, but with consanguinity, press sided with the corporation. They always fight and side with the corporation against the injured individual. Why? Because the corporation gives them money. And Glendora goes to you for justice, and you do another press. That's what happened. Press double-crossed myself in America, and so I went to a federal court for justice, and the federal court double-crossed myself in America and did another press. Instead of these procedural whimpers, you should be dealing with the gravamen. Did Press do it, or didn't he do it? And you don't even talk about that. Did he violate Title 42 of the United States Code, Section 1983 Civil Rights, and 1985 Conspiracy, along with the numerous other laws listed in Glendora's cover sheet, or didn't he? That was what you had to decide. And all of your papers, the three received on October the 18th, and this one received on November the 8th, are superficial and supercilious. Raised eyebrow. Admit, iota, deny grounds. How can a court, quote unquote, that it cannot read and comprehend a complaint, a motion to dismiss, and a submission to file as material fact, and the U.S. Code and the Federal Rules of Civil Procedure qualify as a court? Herein, in addition to being a notice that you have admitted Glendora's charges, the within is a notice of your disqualification, together with a notice of fraud. New. Going back to iota, page 24, Glendora accentuates that a case not ruled on the merits can be brought again. Glendora can sue Press again, appending his supporters and sustainers and seconders, Mordew, Treese, law clerk, and court clerk. Page 26. Discovering the inability that this court to do its American duty as to Press, Glendora finds it philosophic that she did not sue only Press. This court never could have ascertained the truth as to Hansberry, as to No Good Wood, as to John Boach, as to Stephen Toman, as to Peter Lane, as to Kenneth W. Rudolph, McCabe, Tannenbaum, LaCava, Littman. So it's a good thing that I just sued only Press. They can't even handle one defendant if I sued all the other 10. Just one lone defendant has spent and spit out dozens of misfires. Incorporates. Herein, Glendora incorporates her file, her complaint of August the 23rd, 80-page attachment of September the 21st, Terrorist Day, motion for default judgment, Rule 55, Federal Rules of Civil Procedure of Halloween, with findings, questions, charges, and demands for omissions. She herein incorporates all of that as if fully stated herein. Now we're up to Mordew, page 4, with 4 to go. Writes this law clerk, objection to action by the clerk and request for refund of filing fee. Upon filing her complaint, the plaintiff paid the statutory filing fee for this action. The plaintiff now seeks a refund of the filing fee, and the plaintiff requests that the refund, that because, among other things, she feels that the clerk of the court improperly returned papers to her which she wished to have filed in her action. And there's a footnote to that, a disjointed footnote. These people cannot write integrated papers. They have to write disjointed footnotes. Why can't they write integrated papers? That's right, because that takes integrity. Well, Glendora says, Bierman's malfeasance was only one reason for returning Glendora's $350. Law clerk has reading comprehension deficit again. Glendora is entitled to her money back on grounds that this court is advertised as a court of justice, and it is not. This is false advertising, consumer fraud. Glendora can sue for this $350 in small claims court in Syracuse, municipal court. She can add to it $100,000 damages and sue in federal court. She can make it civil rights and sue in New Hampshire. The other reasons her $350 must be returned, and with New York State statutory interest of 9%, are error in comprehension, error in the law, or no law at all. Page 28. First Amendment censorship, denial of right to petition, ignoring all laws listed in the civil cover sheet, transgression of the United States Code and her rights therein, transgression of Federal Rules of Civil Procedure, transgression of the United States Constitution, transgression of the New York State Constitution, denial of due process of law, bias, prejudice, and collusion, failure to admit or deny and give grounds for denying Glendora's charge. Neither press nor any judge has immunity. Title 42 of the United States Code, 1983, and 1985 conspiracy, inter alia, and reserved. An action is a legal proceeding by which one demands and enforces right in a court of law. What did Glendora get? Secondly, is this, quote, a court of law, unquote? Page 29. Glendora opines the law clerk, first job out of school, has not the skill, nor the experience, nor the expertise to stand up to Glendora's Rule 60B motion for relief of order. The law clerks in Manhattan Federal Court are plagued by the same insufficiencies in truth and law, but they're just a little bit slicker. Pi. Teacher says pi r round. No. The teacher said pi r square. And the little girl says no, pi r round. Disjointed footnote, let's go after it, folks. Writing on integrated paper subsumes integrity. Plaintiff also complains that her case was assigned to the undersigned, whose chambers are located in Syracuse, New York. Plaintiff says that she did not file her case in Syracuse, she filed her case in Albany, and she did not give the clerk jurisdiction to move it to Syracuse. She has the right to chart her own litigation. Plaintiff is advised that cases filed in the Northern District of New York are randomly assigned to a district judge and a magistrate judge. All of the judges in the Northern District of New York have jurisdiction to hear cases anywhere within the district. Glendora says, who says? Did Congress make such a law? Who says again? What is your statutory authority? Glendora did not file in Syracuse. Glendora filed in Albany. In the Southern District of New York, a case filed in White Plains is adjudicated in White Plains. unless there is an order to transfer it to Manhattan and vice versa. Where is the order? Again, Glendora has a right to do Article 3 judges, where she files, Albany. What was the reason for Hyde tailing to Syracuse? Reason is conspicuously absent, along with the law. Well, you want to know, folks, it's a chief judge thing. In the federal courts, chief judges are more chief than judge. Griesa. He says it's Grise, but it's spelled Griesa. Bryant was a chief judge. Chief judge in the Boston First Circuit. Calabrese, Winters, et al. It's just another hand tool to defeat justice. Federal Rules of, no, the United States 18 U.S. Code Section 1501 to defeat justice, and of Section 1001 to cover up material fact. Inter alia. Paragraph Rho. Plaintiff contends that this action resulted in a consumer fraud and false advertising because you, the court, are advertised as a court. Well, you are not. And the clerk as a clerk, and you are not. And as giving justice, and you have not. Glendora says the quote is admissible, but read the context. Writes this law clerk, in the first instance, the papers which were previously returned to plaintiff, which were captioned for Supreme Court, Westchester County, were understandably, improperly returned to the plaintiff as a courtesy, since it appeared that plaintiff had misdirected them. Says Glendora. Courtesy is always amiable, but why would there be such miscomprehension when Glendora wrote at the top of the front page, "2. Glendora is assigned United States District Judge. Add to my file." Are they caught in another lie? Yes, they are, folks. I don't have to answer for you. You know they are. Innocent as you claim, Glendora renews her complaint, covering up material fact, Criminal Code, United States Code, Section 1001. The minimum that you can expect of a court, of a judge, of a lawyer, of a law clerk, of a filing clerk, the minimum you can expect is that they can read. And Glendora has told this to you on TV at least a dozen times. And on the internet. Writes his law clerk and signed by Mordew is, plaintiff has now returned the papers to the court and has clearly evinced her intent that they be filed as papers in support of her action. The clerk has now filed the papers as supplemental papers in support of plaintiff's action. Thank you. As Judge Mordew read it and comprehended it, Behrman is not yet absolved. Sigma. When do we get to the gravamen of this case? Press violated civil rights. (33) Together with a dozen other statutes, together with both constitutions, and owes Glendora $83,000. Damages, compensatory and punitive. When do we get down to the cause of the action? Talk. Turning to plaintiff's request for a refund of the filing fee, there is no basis upon which the court can reasonably conclude that plaintiff is entitled to a refund of her filing fee. And we're up to page 5, or more due. And here's some more anti-Americanism. Fee-paying litigants, quote, have no opportunity to obtain a refund or their filing fees to the extent that they withdraw their appeals, and this is nothing but a case. This is nothing but another spit out from a computer, for which there are just as many pros as there are cons, so these spit outs are really washouts. And there's a few of those, and Glendora says that there is no law in the above. All you have is a bunch of computer spit-outs. These are nothing but more bad decisions by bad judges, together with a dozen other statutes. And more violation of same and of the constitutions. And this court owes Glendora $83,000 damages, compensatory and punitive. When do you get down to the cause of the action? Your tinny argument fails. Again, accordingly, quote unquote, is misplaced. Accordingly, quote unquote, means following as a natural sequence, and this does not. And in view of Glendora seeks her $350 be returned, and this court has done 2 cents of honest, has not done 2 solemnly ratified. So we were up to saying that the filing fee was $350 and that this court did not do 2 cents work. Your timing argument fails. Again, accordingly, quote unquote, is misplaced. Accordingly, quote unquote, means following as a natural sequence, and this certainly does not. And in view of lies, refutation, sigma, A through supra above, Glendora sees her $350 to be returned. This court has not done 2 cents of honest and honorable and American work. And there is a precedent, P-R-E-C-E-D-E-N-T. A United States District Judge in Iowa did return Glendora's $250 filing fee. Back then it was $100 less. And so a year later it's $100 more, and it's less justice. Or it's no justice at all. Now we go on to Mordu, law clerk here, first kid job out of school, calling that Glendora wrote a motion for reconsideration. I did not write a motion for reconsideration. That's state stuff. I wrote a motion for relief from order. And why should the Glendora receive relief from order? Because of his error. Nobody could have made more error than Mordu did. Number one, he was wrong about immunity. There is no such thing as immunity. He was wrong about categorically and arbitrarily and summarily dismissing the case against Eric Prest and saying that Glendora could file an amended complaint, but there's only one defendant, and if you dismiss the case against Eric Prest, you dismiss the whole lawsuit. So, you know, what more error do you need than that to have relief from order? It just didn't make sense. It was like a Picasso painting. An eyeball's up here where an eyeball's down here where a mouth should be up here or something. It was heterotaxis. So I have to refute 5 or 6, 7 different times that Glendora did not ask for reconsideration. And Glendora asked for relief from order, which is fully granted by Rule 60B, Federal Rules of Civil Procedure. And we're up to Mordu's page 5, and we only have 3 more to refute. And they talk about returning Glendora's $350 filing fee, and again, over and over and over and over again, there's no law, there's just computer spit outs, and I've told you there's just as many pros and cons that you will find in so-called cases, and that these computer spit outs are washouts. But no law. So there again, it's just dictum. Mere dictum. Everything they say is dictum. Mere dictum. So we're up to page 36 or 7 here. You can grant a Rule 60B motion if there's a mistake in controlling law and if new evidence comes to light. Well, all of this happened, and there's no ambiguity around it, and Mordu was in gross error, and additionally Mordu dissolutely threw off all restraint and fell all over himself, protecting a fellow judge like a Masonic code, even if the person in the defendant's seat is wrong, did commit the crime, cover up for him. And Glendora cites Luke 23 with Jesus Christ suffering in agony on the cross, and yet he says, Father, forgive them, for they know not what they do. God will give these people a second chance, right? And a third and a fourth. We're on page 38. This law clerk is talking about the standard for granting a motion for reconsideration. Well, I am not reconsideration motion. I am the relief from order motion. We're up to Mordu's page 6, 2 to go, and the last one is very short. Alas, dear York. Again, it's conclusory, pathetically conclusory. Try again. You can dodge all you want, but it does not hide the fact. It does not hide the truth. Go ahead, lie all you want, cheat all you want, but you don't cover up the fact. You don't cover up the truth. Accordingly, quote unquote, and then after saying a whole bunch of bad decisions by bad judges, which, as I say, are washouts and spitouts, and no law, then this law clerk says, accordingly, it is dismissed. Accordingly is misapplied. Glendora did not move for reconsideration. Glendora moved for relief from order. This court, quote unquote, defies America once, twice, thrice, and fourth time. Glendora does good and does not get paid. You do bad and you get paid. Isn't that funny? Isn't that funny? You go out and do something good, you don't get paid for it, but the bad people get paid. Something is upside down. Glendora does public access 90 hours a month and does not get paid. It is not allowed to make money in public access. Cecilia Masterelli does evil, taking it off of TV, and she gets paid for that. Eric Press does evil, and he gets paid. And something here is upside down. Fee. Thus the hole that they dig gets dug more deeply, and they don't present any cognizable grounds. It's all conclusories and rhetoric, so that is really done with this so-called court in Syracuse, Northern District of New York, District Court of the United States. And so, looks like she's going to go to the Second Circuit with an appeal, or she can go directly to the United States Supreme Court. I'll go to the Second Circuit because you only have 30 days to appeal. And if you don't appeal in 30 days, there's really a tiny chance you're going to get out of that. So I'm going to appeal before the 30 days is up. And it's being served today, November 17th. Mr. Claus will be here shortly. Mr. Claus looks like Santa Claus, too. Or I could go to the United States Supreme Court, not for a petition for writ of certiorari, or certiorari. I could go to the United States Supreme Court as an original action, because what Mordew did, and Treese did, and the law clerk and the court clerk are so anti-civil rights and anti-constitutional, it can go straight to the Supreme Court as an original action. Again, Glendora is all three of these orders are appealable orders. The order of October 9th, dismissing Press as a defendant in this action on the grounds of immunity, when no such thing exists, and the order of October 10th, Treese is saying that the motion for default judgment should be stricken, and as I told you, I'm going to have to buy a new stereo for you to play the CD songs. That's an appealable order.